Welcome to Law Logical, the go-to place for all things legal. We're thrilled to announce the start of a brand new adventure on our channel. This journey will lead us through the intriguing labyrinth of private international laws, a realm often shrouded in complexity but intrinsic to our globalized world. From the intricacies of marriage and divorce to the nuances of adoption and guardianship, we'll dissect them all. We'll also venture into the often turbulent waters of cross-border disputes, touching upon global contracts, transnational relationships, and insolvency. Sounds intense, right? Fear not. We're here to illuminate these topics with clarity, making sure you feel informed and confident in your understanding. And today, we're setting sail with a deep dive into private international law for marriage in India, a topic that marries tradition with modernity, local customs with international norms. So get ready to dive into the world of private international laws, starting with marriage laws in India. Before we delve into specifics, it's essential to understand what private international law is. Often referred to as conflict of laws, private international law is a set of rules that guides how legal disputes involving more than one country are handled. It's like a traffic director at a bustling intersection of global legal issues, ensuring each case finds its way to the appropriate legal system. Now, why is this important, you might ask? Well, in our increasingly globalized world, it's not uncommon for individuals and businesses to have legal ties in more than one country. Think of multinational corporations, international marriages, or even digital transactions that cross national borders. Private international law plays a crucial role in these scenarios, providing a clear framework to resolve potential disputes. One of the key aspects of private international law is jurisdiction, determining which country's courts have the authority to hear a particular case. This is followed by choice of law, which decides what law applies to the substance of the dispute. And finally, recognition and enforcement ensures that a judgment given in one country can be recognized and enforced in another. Now, let's bring this down to a personal level. Consider an international marriage, say an Indian citizen marrying a French citizen. Where should they marry? Which country's laws will govern their marriage? And if things don't work out, where should they file for divorce? It's here that private international law steps in, helping answer these complex questions and more. Moreover, it's not just about marriages. Private international law touches various aspects of our lives, from business contracts and property disputes to adoption and guardianship. It's the invisible glue that holds together our increasingly interconnected world, ensuring harmony and justice in our global village. Now that you have a basic understanding of private international law, let's discuss how it applies to marriages in India. In India, private international law for marriage governs the legal aspects of cross-border marriages. Now let's delve into what that exactly means and how it applies in real-world scenarios. Imagine a couple, one from India, the other from a different country, deciding to tie the knot. Their decision to marry sets off a series of legal considerations that fall under the purview of private international law. This law helps determine three key aspects: jurisdiction, applicable law, and recognition of foreign marriages. Firstly, jurisdiction refers to the legal authority to make decisions in a case. In the context of cross-border marriages, the question is, which country's courts have the authority to decide on issues arising from the marriage? In India, the courts generally have jurisdiction if either spouse is domiciled in India at the time of proceedings. Secondly, applicable law refers to the law that will be used to decide on the matter. This could be the law of the place where the marriage was conducted, the law of the place where the couple intends to reside, or the law of the nationality of either spouse. In India, it's typically the law of the place where the marriage took place that is applied, but there are exceptions. For example, if our imaginary couple got married in France, but then moved to India, the Indian courts would usually apply French law to any disputes arising from their marriage, as long as it doesn't contradict the principles of Indian public policy. Lastly, let's talk about recognition of foreign marriages. This refers to whether a marriage conducted in a foreign country is recognized as valid in India. The Foreign Marriage Act of 1969 in India allows for the recognition of marriages conducted outside India, provided they adhere to the conditions stipulated in the Act. However, it's not as straightforward as it sounds. This is because India recognizes different personal laws for different religious communities, and these laws may have varying stipulations about the validity of foreign marriages. So the recognition of a foreign marriage in India can be a complex matter, requiring careful navigation of the interplay between personal laws and the Foreign Marriage Act. As you can see, private international law plays a significant role in cross-border marriages in India. It's a fascinating area of law and one that is becoming increasingly important in our interconnected world. While it can be complex, it's also a crucial tool for ensuring that people's rights are respected, no matter where they choose to marry or live. While private international law provides a framework for cross-border marriages, it's not without its challenges. Cross-border marriages in India often encounter hurdles due to diverse national laws and cultural nuances. Let's unpack some of these challenges and explore potential solutions. One significant challenge is the conflict of laws. Imagine a couple, one from India and the other from Italy. They get married in India but later move to Italy. Now, which law applies when they decide to divorce? The Indian law where they got married or the Italian law where they currently reside? This conflict can lead to legal complexities and emotional distress for the couple. Potential solutions? Well, harmonization of laws could be one. Countries could work towards creating unified legal standards for marriage and divorce, which could ease such conflicts. It's a tall order though, considering the diversity of legal systems and cultural practices across the globe. Another challenge is the recognition of foreign judgments. Sometimes a divorce decree granted in one country might not be recognized in another. This could leave the parties in a state of legal limbo. One potential solution could be to establish bilateral or multilateral treaties, ensuring mutual recognition of legal judgments. Then there's the issue of child custody in cross-border divorces. The question of which country's laws should decide the child's custody can be a thorny one. International conventions like the Hague Convention on the Civil Aspects of International Child Abduction could help address such issues, but their implementation and acceptance across countries remain inconsistent. Lastly, there's the challenge of enforcement of rights and obligations. Even if a judgment is recognized, enforcing it could be another uphill task. This could be potentially addressed by bolstering international cooperation and legal assistance. Despite these challenges, private international law remains a crucial tool for managing cross-border marriages. It's a complex field, no doubt, but with thoughtful reforms and increased international cooperation, we can make strides towards making the process smoother for couples navigating these waters. We hope this video has given you a clearer understanding of private international law for marriage in India. As we navigate this globalized world, it's crucial to grasp the complexities of international laws, especially when it comes to matters as personal and significant as marriage. We have delved into the realm of private international law for marriage in India, unraveling its intricacies and nuances. We started by defining what private international law is, explaining how it plays a pivotal role in addressing cross-border legal disputes and how it applies to various domains, including marriage. We then specifically focused on its application in the Indian context. We examined how this law governs marriages involving Indian nationals and foreigners or those taking place outside India. We also discussed the challenges this law faces, such as the lack of uniformity in laws across different countries and the complexities arising from cultural and religious differences. Fortunately, we also identified potential solutions to these challenges, emphasizing the need for countries to collaborate and create more harmonized laws. In today's interconnected world, understanding such laws is not just for legal professionals, but for everyone. Regardless of your profession or background, having a basic understanding of these laws can be highly beneficial. It can help you navigate any legal complexities that may arise in your personal or professional life. So, as we conclude today's topic, we hope you're walking away with a better understanding of private international law for marriage in India. This is just the beginning, and we will be exploring other aspects of private international laws in our upcoming videos. Thank you for watching. If you found this video informative, please like, share, and subscribe to Law Logical. Don't forget to leave your comments and questions below, and encourage others to subscribe for a weekly dose of basic laws of the land. Stay tuned for the next video in our series on private international laws. Until then, stay informed and stay safe.